in camera. Again, overnight, I thought about this matter, and I thought, honorable members, to contextualize my resolution at the end, I should start by the supreme law of the land, the Constitution. And in the preamble of our Constitution, it indicates that in adopting the Constitution, we therefore, through our freely elected representatives, adopt this Constitution as the supreme law of the land, as I said, so as to, and this is the important point, so as to lay the foundation for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by the law. I premise my recommendation to committee on that. But also, honorable members, Rule 119 of the National Assembly directs that all committee activity, we must ensure public involvement in accordance with the provisions of the Constitution. That's Rule 119. And there is another rule, I think it's 184, I'm not sure of what rule it is, that outlines the process in the event we want to take a decision to have a closed session. And that would involve the leadership of Parliament and so on. So having considered all those things, I want to propose as follows, honorable members, that we should be sensitive to the concerns that have been raised by the two witnesses that we spoke about yesterday, and not dismiss their concerns. But at the same time, honorable members, we must also ensure that we maximize transparency in the work of Parliament. I also think, honorable members, that we should never compromise on being consistent and operating in a manner that is fair to everybody. The final point that I want to make, honorable members, is that in considering the proposal that I want to put on the table, I think it's incumbent upon this committee and also on Parliament to communicate to all South Africans that on accepting employment in the public sector, we must understand that that employment comes with having to be held accountable. Whether you're currently in the public service or whether you've left the public service, but anything that happened under your watch, you should understand that you will and must be held accountable. And therefore, honorable members, and I'm raising this of accountability because we toyed with the idea of whether if somebody is no longer in the employ of the SABC, we should not be more lenient. I'm arguing that as long as it happened under your watch in the public service, you must understand that you'll be held accountable. The final point that I want to make, honorable members, is that we've started a process yesterday or the day before and have gone through at least 5 witnesses who themselves came here not because they wanted to come here, but had to endure whatever pressure or pain they had to endure. To change midstream would seem to me to be unfair to those that had to go through the process. Having considered all those facts, honourable members, I want to propose that our position is that no session will be held in camera. It must be very onerous on anybody to come to Parliament to want to argue that he or her session must be in camera, for the reasons that I've laid out now. So firstly, that we put MultiChoice as a witness on hold, and secondly, while sensitive to all the concerns raised by honourable members, by potential witnesses, that our principal position as the voice of South Africans is that there should be maximum dissemination of information that is in the interest of South Africans, and therefore we must deny the request to have any session held in camera. I will then open it up for members to comment on these firm resolutions that I'm putting, or recommendations that I'm putting on the table, and then let's take it from there. Anybody wants to comment? All right, everybody seems to want to comment. All right, let's for a change start here, Mr. Chauke. We'll go up the line, down, and we'll end up with the Honourable Mahlangu. And also honourable members, because we really do not have a debate on this thing. Every member will be given a minute to make his point and we'll take a decision. But let's start with Honourable Chauke.
No, thank you very much, Chairperson. I will firstly comment on the MultiChoice proposal. In fact, I made that proposal earlier. And I will want to agree with you, Chair, that if there are other processes that are currently underway, and therefore I will definitely abide by the decision that you have taken. It's a correct decision. We'll then have to wait and watch the space so that we get to the details of that, and I'm okay with that, Chair. On the other issue of a closed meeting, obvious, in the best interest again of the public and the transparency process that we have been engaging in as Parliament, I will again want to really support the decision that your conclusion that you came up with, which really put us in a position that the public always will be on board in the process. And thank you very much for that.
Thank you, Chairperson. I support your recommendation on the MultiChoice. We can always call them in later. As far as the second point on, as you introduced it, regarding closed in-camera sessions, I concur with you that we have a duty as a parliamentary committee in terms of our rules and in terms of the Constitution. We have a representative democracy based on openness and transparency. And I think we should heed that. Also, our rules, 184, gives effect to that, specifically to allow for public scrutiny of what we do. And we can always, when we get to matters, ask people some of the information they can provide throughout to you, so that it could also inform our business and conclusion of this matter. Thank you, Chair.
Honourable Oliver.
Thanks, Chair. Chair, I agree with both proposals, but I want to land by rehashing the fact that those who come and testify here are not supposed to be threatened by anyone, because they are doing this so as to let South Africans know what is happening in their institutions. Thank you.
Honourable Khoza.
Chair, I'm covered. I support both recommendations. Thank you.
Honourable Phumzile.
Thanks, Chair. I support both proposals. On the first one, the SABC, first and foremost, accounts to Parliament, so they must provide the documents to us. And then on the second one, like we've discussed before, ensure that there's protection for those witnesses that are threatened or are receiving death threats. Thanks, Chair.
Honourable Mahlangu.
Chair, thank you. I support your proposal and what colleagues have said. But I think as a rider to the close issue, you already had some close meetings with several people, including the lawyers of Mr. Maguve, Professor Maguve, and other people, which you briefed us about. And if there are compelling matters that they would like to raise with you, perhaps ahead of the meeting, if indeed there are such things that you could then bring to our attention, we would appreciate it. But I think in principle, we stick to the process that you have outlined, which is fair. And indeed, I would agree with the colleagues who are saying, in case we have people who have been already threatened, I guess those matters should be put on record here in the meeting, and such people should also lay charge with the police. And I think we should also then be supporting them in those initiatives. Thank you.
Honourable Mokwena.
Thanks, Chair. On the multi-choice issue, I think. No, I agree with you 100%. But can we just get an update maybe at the end of the session today as to the progress in terms of getting those documents from the SABC? And then on the second issue, I also agree. We did put Mrs. Mohobo under scrutiny here, and she was threatened. So there's no one else that we should give freedom. So I've changed my mind on that. I do think that we should send a very strong message to whoever at the SABC or anywhere else that is threatening people who come to this platform, that we must lay charges and we must protect these witnesses that come here. There is no one that is supposed to be threatening anyone. We must send a very strong message to whoever at the SABC threatened Mrs. Mohobo or whoever else is going to come going forward. Thanks, Chair.
I thank you, members. So that is the decision of the committee, that matters of multi-choice will be put on hold until all other options have been exhausted, but we reserve the right to call them if indeed we want to call them. And secondly, that all our sessions going forward will be sessions open to South Africans who have an interest in what is happening here. We're not going to revisit these matters again, honourable members, because this decision is a decision taken by a duly correct committee. So I'm hoping that those things are put behind us. And I also note that Mr. Naidu has joined us. Sir, we did get your apology that there were traffic problems, and that was accepted by members, but it also afforded us an opportunity to do a bit of in-house matters. So we'll start with you in a second, and I'm assuming that by now you have caught your breath, sir. Mr. Naidu, please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry. Notwithstanding the fact that you answer that the answer or the document could incriminate you or expose you to criminal or civil proceeding or damages, you are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. I have been informed, Mr. Naidu, that you have chosen to take an oath. I think the document is before you there. If I could just read the one line, if you could just repeat after me, and then thereafter take the oath. I swear by Almighty God
You want me to repeat after you, Chairman? Right, ready.
I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence that I shall give
will be the truth,
will be the truth,
the whole truth,
and
nothing but the truth.
nothing but the truth.
Please say so help me God. President.
So help me God.
Thank you, sir. That have been dispensed with. We will get straight into the business of the day. Mr. Vanara, it is 10:25. If at all possible, sir, because we need to catch up time, can we allow you to do your business until 11 o'clock? After which we'll open up to members in very much the same fashion as yesterday. And just to be warned, Mr. Honorable Mokwena, you'll be the first one, so prepare yourself, and we'll come all the way this way, and then the next will be the other way. Over to you, Mr. Vanara.
Thank you, Chairperson. Mr. Naidu, can you, for the record, state your full names?
Krishna Naidu.
Can you give the committee your academic background, please?
Well, I'm an admitted attorney, acting as a consultant now to the ANC, and I also hold a master's degrees in strategic studies.
You were until very recently a non-executive board member of the South African Broadcasting Corporation, is that correct?
That's correct.
I'm in possession of a statement, and I have placed it before you as well, a copy of same, dated the 8th of December.
That's correct, Chair. That is a statement that I've written out and submitted to the committee yesterday.
Okay. Can you, I see in your statement you deal with 5 issues. You deal with the board's legal incapacity to discharge its duties and taking binding decisions. You deal with the board's abdication of responsibility and management usurpation of the board's responsibility. The third issue dealing with is the unlawful removal of the 3 non-executive board members. The fourth point you deal with in your statement are the attempts by the minister, or the alleged attempts by the minister, the board to remove you as a member. The last one, the contract between the SABC and MultiChoice, correct?
That's correct, Chair.
Can you take the committee then through your presentation around these 5 issues?
Thank you very much. Chairman, I was a non-executive board member between September 2013 and October 2016. In that time, I was also a member of the Audit, Social and Ethics, Risk and Finance, Investment, Procurement and Technology Board subcommittees. I was also deployed by the board to be a trustee of the SABC Medical Schemes Board. Following my consultation in Johannesburg in October 2016 with Advocate Vanara, the evidence leader, at the inquiry, and the subsequent resignation of all non-executive board members bar 1, I wish to adduce evidence on the following matters under oath, which I've taken. 1, board's legal incapacity to discharge its duties and take binding decisions. In terms of the South African Broadcasting Act 4 of 1999, a quorum of 9 members is required to transact business on behalf of the corporation. At the moment, the SABC board has 1 non-executive board member and 3 executive board members who perform their duties in acting capacities. Based on the above, it is apparent that the board does not have the legal capacity to discharge its fiduciary duties. adhere to the board charter and control the affairs of the corporation and carry out its duties as contemplated in terms of Section 13, subsection 11 of the Act. That's the SABC Act. On this legal interpretation alone, absent a long drawn-out inquiry, I hold the view that the National Assembly may invoke the provisions of Section 15, capital A, subsection 1, subsection B of the Act, and recommend the dissolution of the board because the board is not in a position to discharge its fiduciary duties, adhere to the charter, and control the affairs of the corporation due to legal incapacity. Point 2, board's abdication of responsibility and management's usurpation of board responsibility. Generally, the dysfunctionality of a board can arise from one of two sources, Chairman. The abdication of a board of its responsibility or the usurpation by management of the board's responsibility. Abdication occurs where board members, out of laziness, tardiness, or other reason, neglect their fiduciary duties and substantially allow management to run the corporation. Usurpation occurs where management takes over responsibilities which properly lie within the domain of the board. In both instances, good corporate governance suffers. In the SABC, we had a curious cocktail of both abdication and usurpation brought about by an immoral and clandestine relationship between some non-executive board members and executive board members, and which was managed by a simple majority. This immoral relationship led to the creation of two groups at board level. One which was concerned with discharging their fiduciary duties, and the other which was intent on achieving certain outcomes which are not necessarily in the best interest of the corporation. This unhealthy relationship placed Mr. Hlaudi Moenning as a ringmaster and left me with one burning question which I have not been able to answer to this day. Why were so many educated professionals so beholden to a high school dropout? The dysfunctionality located itself along this parallel and manifested itself strictly along this parallel. At times, it got so bad that even if one argued about the time of day, which could have been verified by a number of objective sources, the outcome would invariably be that which the Hlaudi group wanted. My protestations to bring a semblance of sanity to the board fell on deaf ears. For instance, on 9 February 2015, I requested the chairperson, Professor Maguve, to convene a special board meeting based on a letter written to the board by Mr. Gavin Davis, a member of parliament. In that letter, Mr. Davis raised the issue of that the amended Memorandum of Incorporation was ultra vires the Act, the Companies Act, and the Constitution. I informed the chairperson that these issues were new to me. No meeting was called. On 29 April 2015, and in furtherance of my concern that the Memorandum of Incorporation could be ultra vires the Act and therefore unlawful, I brought to the attention of the company secretary, Ms. Teresa Caldenes, some information I had gathered about the distinction between laws of specific application and laws of general application, and requested her to obtain a legal opinion from the SABC's legal department. Nothing was done. The appointment of Hlaudi Moenning in July 2014 as Chief Operating Officer is probably the best example where the curious cocktail between the non-executive and executive board members, aided and abetted by the Honourable Minister, was mixed. The facts are well known. I voted against the appointment of Hlaudi. The manner in which the board dealt with the Public Protector's report left one in no doubt that the board had no respect for good corporate governance, a Chapter 9 institution, and the Constitution and Parliament. Ms. Ellen Shabalala, the previous board chairperson, was a primary driver of this morass of dysfunctionality. Her conduct bordered on criminality. On 27 September 2016, and after witnessing the appointment of Hlaudi Moenning as Group Executive for Corporate Affairs on television, I wrote to the company secretary to impress upon the chairperson the need to convene an urgent board meeting. I received a negative response from Ms. Caldenes about 2 hours before the board was due to meet the Parliamentary Portfolio Committee on Communications on 5th October 2016 in this room. One could go on citing other serious breaches of governance, but in a nutshell, this is where the board went astray and why I believe it was dysfunctional. To enable the Schlaudi Group to manage the affairs of the corporation on a simple majority, some non-executive board members were removed unlawfully, and two unsuccessful attempts were made to remove me as a board member. Point 3, the unlawful removal of 3 non-executive board members. In my view, the late Hope Zinde, Ronnie Lubisi, and Rachel Kalidas were removed as board members on frivolous and unlawful grounds. The late Hope Zinde attended an ANC workshop on communications. 3 other board members, Ms. Imlakaza, Dr. Shizuma, and I attended that workshop and participated in the deliberations. Ms. Zinde was charged for divulging SABC information to a third party without consent, and on a simple majority vote of the board proposed by the chairperson, Professor Maguve, she was removed as a board member. Mr. Ronnie Lubisi was charged for having a conflict of interest for being the named auditor of 2 companies which did business with the SABC. Despite my explanation of what constituted the conflict of interest and Mr. Lubisi's protestation that he did not do any business with these companies, besides registering them, he was removed as a board member on a simple majority vote of the board, proposed by the chairperson, Professor Maguve. Ms. Kalidas was charged with fraud for having left an audit committee meeting early to catch a flight, whereas it was subsequently established that she did not fly out that day. Once again, she was removed as a board member on a simple majority vote of the board, proposed by the chairperson, Professor Maguve. Point 4, attempts by the minister and the board to remove me as a member. 2 attempts were made to remove me as a board member. The first was by the Minister of Communications in January 2015. I was summoned to a meeting with the minister one evening. The minister was not available to meet me, and 2 of her employees conducted the meeting. I was told that I did not attend meetings and I was disruptive in meetings. I told them I was convinced that the information presented to me was incorrect, but if the minister persisted, I would tender my resignation. Whilst driving home, the minister called to apologize, to tell me that I was an asset to the board and should not even contemplate resigning. A few days later, I received a letter from the very same minister asking to show cause why I should not be removed as a board member for failing to discharge my fiduciary duties. I decided to respond in writing to the minister, telling her that her conduct bordered on illegality and that in law, no action could arise from a dishonorable cause. In short, I asked the Honorable Minister to reconsider her action. I never heard from her again. In my view, this was a classic example of a dysfunctional ministry which compounded the problems of a dysfunctional SABC board. Second attempt was by the board in September 2015, after an oversight visit to the SABC by the Parliamentary Portfolio Committee on Communications. The board chairperson, Professor Maguve, wanted to have me removed as a board member because I had raised the issue of the 3 dismissed board members with the PPC. In my written response, I said that my interaction was constructive, intra vires the Broadcasting Act, and within the expectation and contemplation of the shareholder. I never heard from the good professor again on my removal. 4, the contract between SABC and MultiChoice. Prior to my appointment as a board member in September 2013, the interim board had signed a contract with MultiChoice which drew widespread condemnation in the media. At the board meeting in October, many board members raised the issue of the contract with MultiChoice. It was also raised by board members with the then Minister Karim. The chairperson, Ms. Shabalala, acceded to my request that I consider the contract and provide the board with a legal opinion. At a subsequent meeting, I advised the board that the contract was unlawful and submitted reasons for arriving at this conclusion. The chairperson suggested that the board obtain a second opinion, which was subsequently done and which contradicted my opinion. After I made my input to the board, I received a call from Mr. Imtiaz Patel, the Group Chief Executive of MultiChoice. He wanted to congratulate me on my appointment. I obliged because he was an old friend. After some small talk, we went straight into the SABC MultiChoice contract, and he wanted to know what was the reasons for my opposition. Needless to say, I was shocked that the board was so leaky. Nonetheless, I gave him the reasons and suggested that the contract should be terminated and a new contract on more equitable terms should be concluded. He agreed with the proposition and said that the SABC MultiChoice contract was concluded very hastily. This contract and incident was the first stage that I was heading down a long and rocky road.
Thank you, Mr. Naidu. See, this inquiry has to be fair. We can't only focus on the alleged bad issues. Your statement also deals with some good things that took place at the corporation. Can you deal with those?
Thank you, Chair. Chair, not everything about the SABC is bad. I brought along a few meeting board packs to show the professionalism in which these are put together. Sometimes these packs are delivered to my home by SABC staff late at night. These qualities bear testimony to the hard work and dedication of SABC Secretariat. The staff of the SABC constitutes a rich tapestry of experience, knowledge, skill, talent, and institutional memory, and are a priceless national asset in our young democracy. What is required is to conjure up the political will, to do the right thing and place the SABC on a trajectory to enable it to deliver its basic outputs, to inform, educate, and entertain, and play a role in social cohesion and nation building. In that process, we can build a strong state-owned entity we can be proud of. Thank you.
Thank you, Mr. Naidu. In your statement in page 2, paragraph 3, you make a distinction between two groupings in the board. Who belonged to which grouping within the board?
Well, looking from the time of inception, let's go back to September 2013 under the chairpersonship of Ellen Shabalala. Well, she was certainly in the Schlaudi camp. I'm trying to think of, well, Dr. Shidzumba. Yeah, I think they, and of course the three executives, Schlaudi, Moenning, and others. But then the board dissipated quite quickly with the removal of board members, and it left just myself and Ronnie Lubisi was removed, Rachel Kalidas was removed. They were part of the group that were very serious about corporate governance and executing fiduciary duties at the board. And we were left, in the end, we were left with 9 board members, 6 non-executive, 3 executive, and it was just Mr. Mavuso and I that were trying to oppose everything. So, in a way, the outcome of votes were very predictable. It was always 7-2 in favor of the Schlaudi group.
The issue around the amendment of the Memorandum of Incorporation, you requested it be placed on the board agenda. And your response is that it was never done. Were you appraised of any reasons as to why this never happened?
Well, the amendments to the MOI was really initiated by the minister, and it seems that the intention was, one, is to find an easier way to remove board members. And what I found very unusual about that MOI is that it relied on the Companies Act, Section 71 of the Companies Act, to remove board members. But unfortunately, the minister and her crew did not have the courage to put in a provision to admit board members, because if they had put in a simple provision of admitting board members in terms of the Companies Act, then they wouldn't be just left with one board member today. So the fallacy of that whole aspect, and I believe it's ultra vires, the Memorandum of Incorporation on this basis. You cannot substitute a law of specific application, which is the SA Broadcasting Act, with a law of general application. The SABC Act is very, very specific as to the role of the appointing authority for appointing board members and how board members are removed in terms of this inquiry like you're having today. So it's very specific, very detailed. Now, one can't take a simplistic approach as is done in the MOI to remove board members just by simple voting around the table.
My question is, were you given any reasons why this important document would not be a subject of a discussion by the board?
No, we were not given many reasons, except that this was driven mainly by the ministry, and I think with the company secretary who played a role in developing that document. And after I got sight of the document, sometime in July 2014, around there, I then made an input to the company secretary, giving an opinion. I did some research, and I picked up a case in the US, and I told her, look, we needed to research this because that dealt with why it would be unlawful to take a law of general application like the Companies Act and substitute it for a law of specific application like the SABC Broadcasting Act. In fact, nothing was done about that, as I said in my presentation, but that in itself, I thought, made the MOI unlawful. The second point is that it also affected the way executives were appointed in the corporation. I mean, there used to be a process in the past which required some kind of board intervention or approval or certification. But that has been taken away completely, so it became the function of the CEO and the COO to appoint executives. And what I found after the MOI became, law at SABC, you would attend meetings, and every meeting you'd find different people. So you ask yourself, but what happened to Joe Soap who was here at the last meeting? Oh, he's either been suspended or left. So you had this large turnover of staff. They were either suspended or they left. And you had all these acting appointees holding very, very senior positions. Now that in itself is a factor which contributes to dysfunctionality.
I accept you hold strong legal views around the differences of interpretation. And I don't want us to spend too much time there because, as I understand, this matter is a subject of a litigation, is that correct?
It is a subject of litigation, yeah, by those board members that were removed.
I'm interested in your second last paragraph on page 2. You say the appointment of Hlaudi Moenning in July 2014 as Chief Operating Officer is probably the best example where the curious cocktail between the non-executive and executive board members, aided and abated by the Honorable Minister, was mixed. What do you mean by this statement? And secondly, who is the minister you're referring to here?
The minister on that date was Honorable Faith Muthambi. The unusual aspects, firstly, I mean, the board meeting took place late one evening, probably at about 6 or 7 o'clock. And I suppose that was done to accommodate some board members. But what made it even more unusual, apparently the minister was on the premises of the SABC. And it appeared that she had had a prior discussion with the chairperson at the time, Ellen Shabalala. So we had this board meeting, and we were given a legal opinion by an attorney on behalf of Mr. Moenning, who told us what a great chap he was, and that he had been acting for far too long, and there was a need to consider him as a permanent COO of the SABC. So that was the prelude to this discussion. There was some discussion. There was a lot of opposition from those who felt that due process was not being followed. But nonetheless, it led to a kind of split in the House. a narrow split by, I think it was a split vote of about 6 against 5. 6 in favor of his appointment and 5 against his appointment. After that simple decision was taken, the minister was brought in. She thanked the board for having considered that matter. That is a matter of appointing Mr. Muthambi as permanent COO of the SABC. She said she'll consider that recommendation because it went to her as a recommendation from the board. By that stage, it was about 11 o'clock that evening. And lo and behold, by 8 o'clock the next morning, she made a public announcement that Mr. Muthambi was the permanent COO of the SABC. So she probably considered it in her dreams.
At the bottom of that page 2, where you deal with the manner in which the board dealt with the public protector's report, you say it left one in no doubt that the board had no respect for good corporate governance. A Chapter 9 institution of the Constitution and Parliament. Those are very serious allegations. What do you mean by that?
Well, unbeknown to us as board members, the interim public protector's report was given to the chairperson, Ms. Helen Shabalala, in November of about 2013. And this was not disclosed to the board. So when the final report came out in about February or March 2014, as a board, we were very concerned that we were not presented with an interim report, but a final report. It then emerged from the chairperson at a board meeting that, in fact, she was given the report 3 months previously, but because the letter was addressed to her, she thought it was for her personal consumption only and never disclosed it to the board, and I thought that was very, very amateurish in my view. But in the meantime, she had solicited the services of an attorney, and she was busy processing a response to that report, basically in defense of herself and in defense of Hlaudi Motsoeneng. And it also transpired that in that interim period after she had received the report, she had actually made representations to the public protector before the final report was published. So the board had no input into that final report.
Ms. Shabalala was also a non-executive board member. She was not an executive chairperson. Is that correct?
That's correct.
Subsequent to Mr. Mutsoeneng's appointment as Group Executive for Corporate Affairs on television, you wrote to the company secretary. What happened then?
Well, the reason I wrote to the company secretary is that about a week after, I think, the Supreme Court of Appeal made its decision, I made my input to the board, and my input simply was that that decision of the SEA effectively terminated the employment relationship between the SABC and Mr. Motsoeneng. In other words, it was time to pack his bags, that decision in Bloemfontein. But it seems that the board, the executive group CEO, Mr. Gaguma, had gone on his own without broad approval, and based on the advice of some lawyer at the SABC, appointed Mr. Hlaudi Motsoeneng as Chief Corporate Affairs, Head of Corporate Affairs. Now, in my view, that was unlawful. And I came to the conclusion that here we had somebody who had no right to be at a national key point. In fact, he was squatting at a national key point because that appointment was unlawful. So I thought it was appropriate for the board to meet. It was a serious issue, the board to meet and discuss it. But I didn't get a response. In fact, I got a response about 2 hours before our presentation to the Parliamentary Portfolio Committee on the 5th of October, which was about 8 or 9 days later. A negative response.
The last question from myself relates to the example of the Joe soap you referred to, the changing of faces of the executives for various reasons. But I want to link this to the MOI. My understanding is that the MOI, before it was amended, gave the board powers to oversee the appointment of executives. Is that correct?
That's correct.
And that this amended MOI took those powers from the board and gave them to the executives.
Yeah, it vested all those powers in the executives. In other words, changes could occur at a very senior level within the SABC without board knowledge.
Thank you, Chair. No further question.
Thank you very much, Mr. Vanara. Your 5 minutes starts now, Honorable Mokwena.
Thanks, Chair. Mr. Naidu, are you well? Let me just get straight to the point. Where's Hlaudi getting his power from?
I'm sorry?
Where is Mr. Hlaudi Muthambi getting his power from?
I don't know. I mean, that's a question I've been asking myself, even in my presentation. You know, it's very unusual for any individual in a state-owned entity to behave in this particular manner. So either he's on a frolic of his own, or he's getting support by parties that I'm not aware of.
Okay. The amendment to the MOI, are you in concurrence with the belief that it was done solely by the minister without the consent of the board?
Well, it was done substantially by the minister and her team within the ministry, with some participation from the SABC Secretariat. That's my understanding.
But it would have been, it would need to be approved by the board.
Yeah,
and it wasn't.
but the board never participated in the development, other than copies being sent to us from time to time. We raised our objections and made our protestations, but in the end, it was passed.
Do you have the letter in which you advised the minister that the MOI was illegally constituted? The amendments?
Yeah, I've got a copy of a short opinion that I sent to the company secretary, which I will make available to the committee.
And then the public protector's report. Do you have evidence that the minister was advised that the appointment of Mr. Moenning was in contradiction of the public protector's report and therefore illegal?
When you mean the minister was advised, at what point would the minister be advised?
Well, what was she not advised? What was she not advised that the process that took place in order to instate Mr. Hlaudi was illegal? In terms of the report, was she not advised as to that fact?
No, there was, well, two things, I think. First is, at the time the appointment was made, the public protector's report was made public. So the minister would have had an obligation to take cognizance of that fact. And the fact that the person that she was seeking to appoint was damned in that report, was subject to a whole lot of investigations, and the recommendation in that report was this particular individual should go through a process of a disciplinary inquiry. So the question then becomes that was that a proper appointment? Was that a considered appointment? Did the minister apply her mind properly to that appointment? And that's why the Western Cape High Court and the Supreme Court of Appeal made the finding that this appointment was made without proper application of one's mind.
Okay, no, that's fine. Okay, then the executive then appointed him as the group corporate executive.
You're talking about corporate executive or CEO?
No. I was talking about CEO
okay,
then.
thank you.
I'm now talking about the
in September 2016.
Yeah. Was the board advised? Was there a board meeting that happened? Was the board advised of the decision to reinstate him in another position? And was the minister advised on the illegality of that appointment?
Well, as a board member at the time, I read about that appointment in the newspapers. Oh, I saw it on television, sorry, that Mr. Muthambi was appointed as Group Chief Executive, and that prompted me to write this letter to the company secretary for the attention of the chairperson, because in my view, that was an unlawful appointment.
But in light of the fact that the MOI was then amended, is that MOI, the amendments to the MOI, what gave the powers to the executive to then reappoint him at a lower...
Notwithstanding the appointment of the MOI, the appointment of Mr. Muthambi was unlawful, firstly by virtue of the SCA decision. That decision was the trigger that said this person had no place at the SABC.
Unfortunately, my dear friend, Injal.
I had the last one.
Injal, Mr. Muthambi, Honorable.
Chair, thank you. Mr. Naidu, let me start at the end. The multi-choice contract, you have a problem with it. Is this emanating out of your fiduciary responsibility to SABC, or because the media had queried that question?
Well, Chairperson, at the time we joined the board in September 2013, there was this huge media rage about this particular contract. So as part of my fiduciary duties, I offered the chairperson at the time my services as an attorney, and I said, look, let me have a look at it. So I think I was the only board member that really saw that contract. No other board member saw it. So I went through it, drew up a written opinion, gave it to the board, and then I got this call from MultiChoice, and I went across, and and for the reasons, I mean, I can go into the detail, but I don't think this is the relevant stage to do it.
Okay.
But it was clearly an unlawful contract, and it's something that should not have been signed, in my view.
Okay. The next question: the meeting that you had in January 2015, who convened the meeting? Who summoned you to the meeting?
The meeting with the minister, the minister.
Yeah. Was it the minister?
The minister was holding one-to-one, meetings with various board members. And my meeting was set for, I think, 7 o'clock that evening at the office in Pretoria.
But you then met the minister's staff?
Yeah, when I got there, the minister had just popped across to see the president. And so the meeting was started by the minister's advisor and some other gentleman from her department.
You know the people, or you don't?
I know the one person. He was the advisor at the time, Dan, forgot his surname, Mancha. Dan Mancha, I think. Yeah, I don't know who the other gentleman was.
According to you as a board member, do you consider the minister as an internal player or an external?
I think, well, the minister generally, the role of the minister would be one of political oversight. I just think that the minister came a bit too close to the action at the SABC.
The role of the company secretary, especially in the matters that you have raised as...
I think that the company secretary could have done a lot more to give proper guidance to the board. A company secretary is somebody, in her case, she was a chartered accountant, but a company secretary also has to give some kind of legal guidance on procedure. Now, when as a board member you write to the company secretary and say, please bring this matter to the attention of the chair, because it's only the chair and the deputy chair in terms of the act that can convene board meetings. We don't have powers to call board meetings. So we have to submit it to the company secretary, who then brings it to the attention of the chair. Now, I thought that the company secretary should have realized the import of some of the issues that were going around without proper discussion, without proper investigation. For example, the appointment of Mr. Muthambi as Group Chief Corporate Affairs Officer, that was a serious matter which warranted a meeting. Now, a company secretary should implore upon the chairperson, who is not a lawyer, who does not have legal experience, and probably even less experience as chairperson in terms of good corporate governance, should advise that gentleman that, look, I think this is sufficiently serious to warrant a meeting. Now, that's where the company secretary came short, in my view, on many instances.
Chair, assume my time is over.
No, you got a minute, sir.
Oh, thank you. Wait. Now, as a member of the risk committee, did you often review? I mean, King 3 directs that board members should at least review the risk profile, risk policy, and what have you annually. Were you doing it over your period in the SABC?
The risk committee met regularly, quarterly. In fact, we met every 3 months, and we did a very thorough analysis of the risk facing the corporation. I mean, all the risks, not just financial, physical risks, technology risks in technology.
I want to then assume that the things that have been raised here as red flags would have been contained in your risk analysis profile.
Depending what things,
well, the things that we're talking about, your MultiChoice, your minister's interference, your secretariat ability.
We didn't deal with those elements of risk. The MultiChoice, if you recall, was dealt with right at the outset in September 2013. The minister's role within the SABC is not something that would ordinarily fall within the ambit of the risk committee. We had terms of reference for the various subcommittees, and that did not fall within the terms of reference.
Thank you so much, Mr. Naidu. Can we move over to Honorable Van Dam?
Thanks, Chair. Mr. Naidu, so I just want you to talk to me through, sorry. So on the 20th of September 2016, the SCA denies Mr. Muthambi leave to appeal, which means he must pack his bags. 2 days later, there's a draft resolution circulated to all board members requesting that he be appointed as acting COO. And then on 27 September, he's instead appointed as GE Corporate Affairs. What happened between the 22nd of September and the 27th of September?
I'm not aware of, nothing has happened in my view as a non-executive board member, but I can only piece together what happened after, after the fact. Some of us, I mean, in my speaking for myself, I disapproved of that round robin resolution to appoint him, and in my comment section on the round robin document, I stated why. Because it would have been unlawful to appoint him pursuant to the SCA decision. Normally these round robin resolutions go to the minister in the case of Mr. Muthambi because he's one of the 3 executives. And I think the minister was persuaded by that argument and she did not appoint him as COO. And then it was up to James Aguma, who was acting CEO, who then took it upon himself on the advice, as he says, on the advice of the lawyer of the SABC to appoint him as head of corporate affairs. So that's how it came about. So that's what happened between those 5 days.
Yes, the GE Corporate Affairs position was not approved by the board, am I correct?
No.
Yes. And then Ms. Bessie Tungwana's appointment instead as acting COO, was that approved by the board?
No, I mean, I only realized she was the acting CEO when I met her here on the 5th of October.
So that would have not been approved by the board?
Now, ordinarily, it should have been approved by the board or gone to the minister as a recommendation from the board, but it never came through the board.
Okay, so who would have approved that appointment then? It would have to be the minister?
The minister would make the final appointment acting on the recommendation of the board.
Okay, so since there was no board approval, one could then say that it was a decision taken by the minister without approval from the board.
Well, I'm not even sure whether the minister approved that appointment, because my understanding is that because the board had not made the recommendation, Mr. Kwana's calling herself the COO was unlawful. You know, so even if the minister appointed her, it would have been an unlawful appointment.
But I mean, because so one of the witnesses said yesterday, the minister is a lawyer. She's aware of the legislative requirements. She should have known that she cannot approve an appointment which hasn't been approved by the board. Am I correct?
Yeah, and it's not difficult to remember that there's just 3 top executives at the SABC. We're not dealing with 3,000 people. Now, it's simple to remember as a minister that these 3 people, there's a due process. They must be considered by the board, recommended to me, and then I apply my mind. So it's not difficult for the minister to remember that.
So that appointment would essentially be unlawful.
It is unlawful.
Right. The draft resolution on the 22nd of September, who would have been that source of that draft resolution?
Well, I've got a copy here. Normally the resolutions are put out by the company secretary, Ms. Caldenes.
On instruction of...
Presumably on the instruction of the chairperson.
All right. One more question, Chair, if I've still got time. On the 1st of August 2016, Mr. Moenning announced publicly that he had decided to give 50,000 each to 180 local musicians. Would that been a decision which would have
well, if he
been
gave
approved
it out
by
of
the
his
board?
own pocket, that's fine. I don't have a problem. But if it was SABC funds, then it never came through the board.
It was SABC funds, so that was
well,
not...
then it wasn't approved by the board.
Are you aware of any other decisions taken by Mr. Moenning which would have required board approval that didn't have board approval?
I remember there was this controversial decision about local content. You know, Mr. Moenning decided that there must be 90% local content so that more money can flow to local artists. The sentiment was fine, but the manner in which you went about it was wrong, in my view.
Thank you so much. Sir and ma'am, could we move over to the Honorable Khoza?
Thank you, Chair. First of all, let me probably start by imploring on you, Mr. Naidu, to be as brutally honest with us as possible and be frank with us, because the intention is to restore good governance at SABC and ultimately to all the state-owned enterprises. Having said that, Chair, sir, as a lawyer, would you concede that there had there not been political interference, Mr. Moenning would not have been appointed either as COO or GE Corporate Affairs?
Well, you know, to get appointed at that level would require some kind of political intervention, assuming one follows due process. Ultimately, the minister has to confirm the appointment of those people. Now, if they were appointed absent due process, then that's political interference.
Thank you. Would you probably identify other political key players other than the minister that you think might have played a role in this process?
Well, I think, you know, I was quite surprised by the views of the previous Parliamentary Portfolio Committee regarding the 3 non-executive board members that were dismissed. You know, it was clear as daylight that was unlawful. But for some strange reason, that Portfolio Committee took the view that it was lawful. So, you know, how does ordinary sane members of Parliament come to that conclusion? So that was a bit startling.
So are you suggesting that the Portfolio Committee also played a role, the Portfolio Committee on Communication played a role somehow?
Well, unless, if it wasn't a political intervention, then they probably were not clued up on the law.
Okay, thank you, sir. Could you kindly identify, earlier on you alluded to the fact that there were 3 points of contention with the multi-choice contract. Could you identify at least the 3 in their chronological sequencing, according to you?
In that particular contract?
Yep.
I can give you the main point of contention, because
Okay.
I think it might be a bit awry of me to now go into commercial confidentiality issues. But the thing
we won't
that's
allow you to do that. The role of the board is fine if you went to that one, but we don't want to get the nitty-gritty of...
Okay, but I can just give the main issue in that contract that raised a flag for me as a practitioner is that contract purportedly was an agreement by MultiChoice to use archival material of the SABC. I mean, that was the basis of that contract, but it was made subject, the entire contract or the payment to SABC of that, under that contract was made subject to the condition that the SABC will adopt a particular position on a set-top control. Now, I found that very, very strange and totally unrelated, and that's why that contract was unlawful. Secondly, of course, the person that signed it had no authority to sign that contract.
Thank you, sir. I just want to ask you something that has got to do with the retrogression of the financial, the audit opinion by the Auditor General and the irregular expenditure. As you know, you came from 3.4 billion in almost 3.4 billion in 2013, 2014, 2015. You improved it drastically. But then 2015, 2016, you started going back to, almost going back to where you were. What do you think are the key main factors that are leading to this state of, retrogression?
Well, the factors given to us by the executives of the SABC was that there was a downturn in the economy, so that there was less income on advertising revenue. So, I mean, that was a fair point to make. That led to the retrogression you speak of, honourable member. Secondly, there was a write-down of license fees. We had about 2 billion rand of unpaid, uncollected license fees. And these things were outstanding for a very long time. And the debate was the question of prescription. Does it prescribe after 3 years, or does it follow the state rule of 15 to 30 years? That debate went on for a year. And this year we resolved that it was a 3-year prescription. So we had to write down about 2 million rand we had to write off 2 million rand of license fees.
2 million or 2 billion?
2 billion, sorry, 2 billion. And then there were certain other issues concerning the VAT. There was this debate between SABC and SARS on when do you charge VAT when you pay license for the SABC. Is it at the time you issue the license? Is it on accrual or on invoice? And Mr. Moenning and the group CEO, Mr. Aguma, spent a fair amount of time and achieved a measure of success, in my view, in trying to resolve that dispute, although it's still unresolved. So these factors taken together led to a retrogression in the financials.
Thank you very much.
Okay, thank you, sir.
The Honourable Oliver.
Thanks. Sorry. Thanks, Chair. I'm partially covered by my colleagues except for 2 areas that I need clarity on, Mr. Naidu. The first one is to say, you sat in about 5 subcommittees at the SABC, and those subcommittees are supposed to have resolutions that are taking the institution forward. What impact did resolutions of all the committees you sat on had on the running of the institution?
I think the subcommittees were well run. The debates were very good in the subcommittees, and the resolutions were good, all directed at benefiting and furthering the interests of the organization. The dysfunctionality came in the 2 camps, so to speak. So, in other words, one can't fault the functioning of the subcommittee, which led to dysfunctionality. I think the dysfunctionality came in the manner in which certain non-executive board members, together with certain executive board members, took decisions in the corporation.
Are you, in a way, indicating that there were good resolutions which never saw light in terms of implementation?
No, the subcommittee resolutions are mainly there to support the organization. For example, on the audit committee, which I sat on as a member, we looked at the past problems in the corporation, how we could resolve them. like, for example, writing up an asset register, which didn't exist in the past. So it was all developmental issues leading to a better SABC.
And the last one is, when you received a letter or when you responded to the chairperson when he wanted to take you out of the board, did you respond in Braille?
No, I responded in normal English, in writing. Yeah.
Thank you very much.
Maybe that's why he didn't get back to me. He didn't see it.
You done, ma'am? You done? Honorable Killen?
Chairperson, thank you. I would like to ask Mr. Naidu, first of all, when you started, was there any induction program for new board members? And were you sort of everybody brought on par as far as the legislative framework is concerned? And that includes that at that stage, the Memorandum of Incorporation.
Yeah, I think that was one of the shortcomings, and I know that the company secretary complained very bitterly about the fact that the board members were not properly inducted into the organization. And the reason being that when we were appointed as board members, there were several issues consuming the organization, so we had to get straight into the issues. I mean, the SABC MultiChoice deal, and then in the next year we had the whole Schlaudi Moenning appointment issue. So I think that was a major failing. We should have been properly inducted, and perhaps we could have added much more as board members to help the corporation.
Thank you, Mr. Naidu. Secondly, you see, that is part of the problem as from our perspective, is clearly there were individuals driving from the chair position as sort of an executive chair position, whereas it was very much an organization based on board decision making. So that also contributed to dysfunctionality. Secondly, I would like to come back to the amendments of the MOI. When were you made aware, and is that not a board function to adjust the Memorandum of Incorporation? We have two copies of different ones. One signed in October 2014 and the other one signed somewhere in 2016. Are you aware of those? Have you received it? Were it discussed? Any of those documents, were they discussed?
We received draft copies of the MI from time to time. You know, there were several amendments being made to it. And I think around 2014 or 2015, I can't remember the date, it was subsequently approved. But the problem with the MOI, it was done, I think, in contravention, in my view, of the Broadcasting Corporation Act, to some extent the constitution of the country. So when you start amending documents like the MOI, and you don't take due cognizance of the legal framework in which that MOI should have been drawn, that's where the problem started, in my view, and that's why I believe it's ultra vires the act.
But you, as a lawyer, and clearly it should have been a very difficult process for you to belong in a board as a legal person. Did you at any stage put anything in writing apart from alerting the company secretary? Did you present any document to the board? Did you say, this is ultra vires, we cannot go on like this is against the Broadcasting Act, etc.? Or did you not have such an opportunity?
Now, I've written about 3 or 4 letters to the board through the company secretary offering legal advice. I mean, that was my expertise, and that's why I joined the board in the first place, because I was told when I was recommended to join this board that this board needs some legal advice, so please consider applying, and which I did, and I was appointed. So my expertise was to help a board that had problems at the time of the appointment, but needed advice. So we went in with good intentions, thinking that, with our little expertise, we could make it a better SABC.
Then the Public Protector report, when that was released, it was in fact shortly after you became a member of the board. And subsequent events then turned out that a person that was accused of, well, the Public Protector's comment here is saying, allegation that Mr. Moenning committed fraud is substantiated. Did you at any stage during the meeting where he was appointed in July, did you at any case at any stage raise that issue? Did you put it in writing to say that we cannot endorse this because of the findings of the public protector?